Contracts 1 revised in English language. General principles of law of contracts. Dear student friends, today I wish to take up the meaning, definition, elements and different kinds of contract. This is my 183rd lecture. Before going to take up this lecture, let me take 1 minute with your kind permission to pray God, pay homage to my reverend parents, late Ragapurao, late Srimati Kantaratnam, late my wife, Mrs. Balivada Rega Tirumala Gauri, my co-associate in academics. I express my deep sense of gratitude to the godfathers and publishers. I express my heartfelt thanks to the authors of the textbooks and publishers of articles and research papers in internet. Finally, I express my deep sense of gratitude to my students, friends who are instrumental for what I am now. Today, what is a contract? What is the historical background of this Contract Act? I explained in the last class. Today, I directly take up in meaning, definition, elements and kinds of contract. The word contract is derived from the Latin word contractum, which means drawn together. The word contract is derived from the Latin word contractum, which means drawn together. When two individuals, two parties come together in connection with performance of a particular transaction in particular way, we say that they come together, they got together to fulfill some job, take up some activity for the mutual benefit. So that is why the word contract is derived from the Latin word contractum, which means drawn together, two individuals or two parties. The contract is an agreement entered into between two or more parties subject to certain terms and conditions for a lawful consideration. This means contract is an agreement. Agreement means when two or more individuals come together to do a particular activity or not to do a particular activity or abstain from doing a particular activity for some consideration, which is of course consideration. When two or more parties come together, agreement entered into between two or more parties, subject to certain terms and conditions. They put some conditions, terms and conditions, subject terms and conditions for lawful consideration, to get something in return lawfully, subject to terms and conditions for a lawful consideration. That is called contract. Contract is an agreement entered into between two or more parties subject to certain terms and conditions for lawful consideration. What is consideration and all these things we are going to discuss in detail. Agreement. What do you mean by this word agreement? When two individuals or two parties agree to a particular thing in particular sense, they are said to have been agreed to a particular thing. That activity is called agreement. This agreement may be oral or written, express or implied. Oral means words of mouth. Written means putting the activity in writing. Oral or writing. Express or implied. I tell you in detail. For example, A wants to sell his house. B wants to purchase the house. A express means I wish to oral. Mr. B, I want to sell my house. Then B says, yes, I am willing to purchase your house. That is oral. Orally, they do not come to any agreement. Sometimes they do not come to any agreement. It is called oral. Secondly, if they put it in writing, it is a put it in writing. A wants to sell the house, B wants to purchase the house. It is put it in writing with witnesses and necessary stamping, then it is called written. So what is express implied? Express means express is, suppose in a market the vendor cries 1 kilo apple, 1 kg apple 100 rupees, he cries, that is express. Suppose a woman, a vendor keeps a basket of apples in the market, she doesn't cry, she is simply standing at that. So that is, if we ask what is the price of 1 kilo, she will tell it is implied. So express means we can infer the nature of activity can be inferred from the conduct of the party. Suppose if a housewife takes a basket full of mangoes, generally a neighbor will ask, at what rate you purchase? Somebody on the road, anybody may ask, at what rate you purchase? Suppose if a vendor carries basket full of mangoes on head and walks in the street, and at what rate you sell 1 kilo? That is the question. Express or implied in the sense, depending on the circumstances of the case, we can infer whether she purchased the fruits or she is going to sell the fruits. That is express. So the contract is an agreement between two or more parties. So this particular party and that particular party will agree to a particular thing in the particular sense, then we call it as an agreement. Both agree for an instrument, that is called agreement. Is an agreement. So this agreement constitutes two things. One is offer and other is acceptance. These things I will explain in detail in offer and acceptance. To agree. Agreement entered into between two or more parties. Two or more parties. When two parties, when three parties, we will discuss later. Subject to certain terms and conditions for lawful consideration. What will be the terms and condition? The house is for 50 lakhs. They will pay 10 lakhs advance. The remaining 40 lakhs will be paid in a particular period. It should be registered at a particular place. The party should meet. All these things are called terms and conditions. So, contract is an agreement entered into between two or more parties, subject to certain terms and conditions for subject to certain terms and conditions for legal, subject to certain terms and conditions for lawful consideration. What is the lawful consideration? It's significant. We are going to discuss in detail in that particular point. Now coming to the contract meaning is over meaning. So contract meaning is completed. Now definition. What do you mean by definition? What is the definition of contract? Here there are several definitions given by different authors, but ultimately we have to concentrate on two definitions. Number one is basing on that this entire topic is chapter is based. That is in section 2H of Indian Contract Act. Section 2H of Indian Contract Act defines contract as an agreement enforceable by law. Section 2H of Indian Contract Act defines contract as an agreement enforceable by law. Agreement enforceable by law. Agreement means one party is ready to do one thing, other party also is ready to do one thing. When both the parties are ready to do a particular thing, an agreement can be constructed. An agreement can be constituted, but that agreement must be enforceable. That agreement may be enforceable. If it is not enforceable, it is not a contract. For example, A wants to sell the house, B wants to purchase the house. So this is a lawful contract. It is for lawful consideration. A wants to sell his house for 50 lakhs, B wants to purchase it for 50 lakhs. So that 50 lakhs is consideration to A, house is consideration to B. So it is that if A fails to sell, B can enforce. B fails to purchase, A can enforce. A can demand. A can go to court for specific performance. So the enforceability means this. So legal agreements are enforceable. Logical agreements are not enforceable. Legal agreements are enforceable. Logical agreements are not enforceable. Legal agreements alone will give rise to legal consequences. legal agreement will give rise to legal consequences and create legal relationship. But logical agreement will not give rise to legal consequences. They cannot be enforceable. Enforceable means so if A doesn't sell the house for the if in case of hike of in view of hike of the house prices, then B can file a case against A through court of law for enforcement. So suppose B stops purchasing, A can file a case against B for its enforceability, for getting it done. So that is what is called enforceable. A wife can file a case against husband for her maintenance and other basic needs. But if husband promises her to purchase diamond necklace or luxurious car, she cannot file a case against husband for diamond necklace or car, costly car. So that is why certain activities are enforceable, certain activities are not enforceable, because some activities are logical, some activities are legal. Only legal agreements are enforceable. In an agreement, one party makes offer, other party makes gives acceptance. Offer plus acceptance is put together. An agreement is created. An agreement is created. It may be oral or writing, express or implied. If that agreement is enforceable, that agreement will become a contract. That is why Section 2H of the Indian Contract Act enunciates that all an agreement enforceable by law is a contract. In your examination, question may be asked like this: an agreement enforceable by law is contract discussed. Then you have to answer instant statement, instant phrase. This statement refers to section. This statement is the definition of contract under Section 2H. If the an agreement enforceable by law is contract discussed, if question is asked, you have to write in the first sentence this statement: a contract, an agreement enforceable by a contract is a definition under Section 2H of the Indian Contract Act. First sentence. For this statement can be better justified by explaining its meaning, explaining the meaning, definition and elements of contract. Sometimes question is directly asked as all contracts are agreement, but all agreements are not contract. Question may be asked like this. So I do agree with this particular statement, because agreement is the first stage, contract is the second stage. Good agreement or bad agreement, all are agreement. May be lawful agreement, unenforceable agreement, valid agreement, or it may be any agreement. But those agreements which are enforceable by law are contracts. Which are enforceable by law are contract. If an agreement is not registered, suppose an agreement to purchase two-wheeler, four-wheeler or removable property, is agreement is made, because there is no title. There is no title to the seller, and if the seller doesn't have title, it is not transferred by registered instrument. It is not transferred by registered instrument. That is not enforceable. That is not enforceable. So that is why suppose a married woman is there, a man and woman live together. If a child is born, some legal rights cannot be available. So suppose if that woman, after spending some time, a husband leaves her, she cannot bring an action for restitution of conjugal right. She may not be able to claim maintenance. Such problems are there. So some agreements are enforceable, some agreements are not enforceable. Only agreements that give rise to legal consequences are enforceable. So that is why this is the meaning of contract. Next definition is Section 10 of the Indian Contract Act defines contract. When two competent parties within the meaning of Section 11 and 12 of the Indian Contract Act freely consented to, within the meaning of Section 14, not influenced by Sections 15 to 22 of the Act, entered into an agreement not declared void under Section 23, not subjected to agreements opposed to public policy under section 26 to 30. For a lawful consideration under section 2D, that agreement is a valid agreement and becomes a contract and is enforceable. First definition of contract is section 2H, an agreement enforceable by law. Second one is according to section 10 of the Indian Contract Act, when two competent parties within the meaning of section 12 and 11 and 12 freely consented to under section 14, not influenced by section 15 to 22, enter into an agreement not declared void under section 23, not affected by public, not affected by public, opposite to public policy under section 26 to 30. For lawful consideration under section 2D, that agreement is called valid agreement. According to section 10 of the Indian Contract Act, when two competent parties freely consented to enter into an agreement not declared void for lawful consideration, that contract is valid contract. These 4 points we will discuss in detail. In detail in this chapter, in brief in this chapter, in detail in separate chapters. Competence of parties, lawful consideration, free consent, capacity of parties, all these points, agreement not declared void under section 23, followed by section 26 to 30. These aspects we will discuss in detail. Now, contract meaning is over, definition is over. Now, elements. To constitute a valid contract, some conditions are to be fulfilled. To constitute a valid contract, some conditions are to be valid. Just like if you want to take admission in law set, you must be qualified as a graduate for 3-year course, or you must be qualified the 12th standard or intermediate for a 5-year course. You must fulfill some particular age limit if insisted. You must fulfill some. Percentage if insisted, 45% or 50%. But next you have to fulfill entrance examination, payment of fee, all these things. If all these conditions are fulfilled, then only your admission can be entertained. Your admission will be valid. Otherwise not. If law set is not there, 90% is there, you will not be taken, except in cases of management quota like this. So that is why how you have to fulfill certain conditions for admission into any course. Similarly, a contract to be valid and enforceable, it must contain some valid ingredient. So now we have to take up essential elements or ingredients or requisites or qualifications or conditions of a valid contract. First condition is two parties. To constitute a contract, there must be not less than two parties. Two persons or two parties. In a contract for sale or mortgage, pledge, whatever it may be, one side one party, other side one party. One side the number of parties may be one or more, that side may be one or more. The seller may be one or more, buyer may be one or more, both sides more than even two or more, but the parties must be two. In a contract of sale, mortgage, lease, everything, there will be generally two parties. In some cases, there are three parties. In a contract of guarantee, there will be three parties. When you go to court, when you go to bank for loan, the bank will ask you for security, because in case you will not be able to repay the amount, some other person should come into picture, must take responsibility to pay. So then when you seek loan from a bank, bank will insist some security. That surety is also called guarantor. You will be the main debtor. You are the principal debtor. Your surety will be the next secondary debtor or guarantor or surety. Then the banker will be the creditor. In such cases, there are three parties: principal debtor, surety, and creditor. In certain cases, a stranger to consideration, in the sense trust, trust owner, trustee, and beneficiary. In such cases, three parties will be there. Three parties will be there. What is private trust? What is public trust? I will let you know in course of time. So this is with reference to contract, meaning and definition. Now after meaning and definition, we are proceeding to the element. The first one is two parties. To constitute a contract, there must be not less than two parties. One party makes promise or offer, other party will give acceptance or willingness. So the first party who makes a proposal is called proposer. Who makes promise is called promisor. Who makes offer is called offerer. So the person who out of these two parties, the person who initiates the contract, who makes a beginning of the contract is called proposer or promisor or offerer. So the promise made by it is maybe promise or offer or proposal. So this is when this promise is made to another person, that person is called, other party is called promisee. If the offer is made to other party, that party is called offeree. If the offeree gives acceptance, gives willingness by acceptance, that is called the promisee will become, the status of promisee will become acceptor. Before acceptance, the other party is called promisee or offeree. After acceptance, the other party is called acceptor. So this is the position. Suppose when two persons are there, a boy is there, girl is there, and the boy has inclination to marry the girl also has inclination to marry the boy, but whoever makes proposal first, whoever makes promise proposal first, that if the girl makes proposal first, girl becomes the proposer or promiser, then the boy accepts, boy will become the acceptor. So suppose if the boy first proposes, boy becomes a proposer or offerer, and then girl becomes promisee and acceptor later. When from whom the proposal comes out, exists, that person is called offerer, promisor, offerer. Same. Promisee before acceptance, after acceptance, the promisee or offeree becomes the acceptor. So that is why to constitute any contract, there must be not less than two parties. There may be two parties may be single individual and single individual. Two parties, one side one or more, or other side also one or more. So each party may be singular plus singular in number or plural in number. To constitute a contract, there must be two parties. These two parties, one party is offerer, other party is acceptor. The offer and acceptance must be valid within the meaning of Section 2A and 2B of Indian Contract Act. Section 2A defines a valid offer. Section 2B defines a valid acceptance. So this is what is called this thing, offer. Now, where two parties is there. So this point is subject to two conditions. One is consensus ad idem and legal consequences. Consensus ad idem means when two parties want to come together for a particular activity or transaction, there must be consensus ad idem or identity of minds. If that identity of minds is not there, suppose in Bahubali 2, what happens? Devasena. Then the alliance is there. The people of the parents of Devasena and Devasena thinks that the bridegroom is Bahubali. But the offer from this side is the bridegroom is Rana, so called villain. So there is no identity of mind. A has two houses, one in Ramnagar and other is in Krishna Nagar. He wants to, he offers his house, Ramnagar house, to be for sale. B agreeing that A has only one house that is in Krishna Nagar and agrees to purchase it. But when they come to point in agreement, simply agreement, then subsequently it is given to understand that it is not Ramnagar house, B Nagar house, B. So there is no any identity of mind. The contract is void. There is not valid. So like this, there must be consensus ad item or identity of minds. So what a particular activity, the subject matter of the contract must be one and the same in the eyes of both the parties. That is both offeror and acceptor. The subject matter or material object of the contract must be one and the same. So the subject matter is house. Coming to the next point, legal consequences. The contract, an agreement must give rise to legal consequences. If it gives rise to legal consequences, in the absence of, if the contractual obligation is not performed by this party or that party, that other party is called aggrieved party, he can approach the court for specific performance or necessary damages. So it must give rise to legal consequences. Legally wedded wife can bring an action against husband for maintenance or restitution of conjugal rights or anything. If the unmarried illegal contact woman with a man cannot bring an action against the husband for restitution of conjugal rights or any other relief. So similarly, if the suppose a married woman is suppose in Balfour versus Whistle, Balfour is a relevant case on this point, then the husband in this instant case left for London from Sri Lanka, and he made a promise to wife to send some pocket money, but failed to send. Wife brought an action against husband for that pocket money. So the pocket money is a logical offer. It is not a legal offer. It doesn't give rise any to raise legal consequences, and the case was dismissed. Similarly, I gave previously one example. Suppose if the husband doesn't provide basic needs, maintenance to wife, wife can bring an action against husband for maintenance. But if the husband could not fulfill the ambitions of wife, that 2-3 crore car or diamond necklace like that, she cannot bring an action against the husband. So only legal agreements that give rise to legal consequences or which construct legal relationship are maintainable in the court of law. But those agreements which do not give rise to legal consequences are said to be logical and are not enforceable. This first point is over. Second, offer and accepted, two parties accepted, consensus item, and all these things are over. Next one is consideration. Next important element for contract is consideration. Consideration is price of the contract. Suppose the seller sells house for 50 lakh, buyer purchases the house for 50 lakh. So house becomes consideration to buyer, 50 lakhs becomes consideration to seller. So if in the absence of consideration, it becomes gift. So the consideration price may be more or less immaterial. 1 crore house may be given to 1 lakh or 1,000 rupees. Whatever, consideration need not be adequate. Suppose if no price is received, there is no price. If it is the house is transferred without a single pie, then only it will become a gift. Suppose we do service and take salary, then it is not we receive salary. If we take pension, it is absolutely a gift. So receiving something for doing nothing is a gift. So the person who gives is donor, the person who receives is called donee. So if it is the price, the person who gives transfers is called transferor and seller. The other person, the transferee, is called transferee or buyer. It is for some particular consideration. So consideration means for any contract to be valid and enforceable, it must exist lawful consideration. The consideration must be lawful. It is legally admissible. Suppose I will give you 10 lakhs, you go and kill somebody. It is illegal. It is criminal conspiracy under section 120A, punishable with under section 120B. Suppose if the consumption of alcoholic drinks is abolished by the government, if any contract is entered into between two parties within the state for sale and supply of alcoholic drink, it is void. It is void. Suppose whatever activity is prohibited by but that state, if that activity is taken up, it is not and it is not allowed. So that is why a consideration must be lawful. I will give you 5 lakhs. Go and break the head of somebody. It is illegal. So like this. So any suppose my son got could not get good rank. You provide admission in medical in through back door. I will give you 25 lakhs. But the original management quota is 1 crore. If 25 lakhs is given to somebody through back door, maintaining rank like this, that is also illegal. Illegal activity by illegal means. So that is why contract to be valid, it is supported by the lawful consideration. A contract without consideration is void. If consideration is not there, that contract is invalid or void. So the details of this consideration we will discuss separately in a separate chapter. Stranger to contract, privity of contract. Stranger to contract is not void, not valid. Stranger to consideration is valid, and all these conditions of consideration, all these things in detail we will discuss in the next chapter, as a following chapter. So offer and acceptance will be studied in as a second chapter. A consideration will be studied as a next chapter. Next important topic for discussion is conditioning is consent, free consent. A contract to be valid and enforceable, there must be free consent of the parties. Both parties must have free consent. Consent means when two parties to agree to a particular thing in the particular sense, the parties are said to have been consented. If the consent is given by both the parties without any flaw in consent like coercion, undue influence, fraud, misrepresentation, mistake, that consent is called free consent. A wants to marry B agrees to marry. Whether they are interested or not, we don't know. Suppose B tells B, warns A, if you don't marry me, I will commit suicide. Suppose if I don't marry, she may commit suicide. B marries A, then subsequently B can avoid the contract. B can avoid the marriage. Suppose in a marriage, for younger daughter, beautiful younger daughter is shown, and a marriage, elder daughter who is not beautiful got married, then that is why it is the one that is called fraud. That is called fraud. Coercion, threatening one party to commit any crime. That is called this thing. Undue influence, superior person influences the inferior to contract. Suppose secretary insists the principal do some favor, that is undue influence. Similarly, a bank manager insists the clerk to let out his house for 5,000, for which the rent is more than 10,000. If he 10,000 rented a house, he doesn't give for 5,000. The manager may stop his promotion and all these things. That is, if out of threat or fear from this manager, the clerk may do unwillingly. That is called undue influence. So mistake, knowingly committed, making statement knowingly, it is fraud. Making statement unknowingly, innocently is called misrepresentation. Mistake of law, mistake of fact, unilateral mistake, bilateral mistake. All these aspects we will discuss in detail. So, a contract to be valid and enforceable, there must be free consent of the party. Section 13 defines of consent. Section 14 defines free consent. A consent is said to be free if it is not influenced by flaws in consent. That is, the flaws are coercion, undue influence, fraud, misrepresentation and mistake, from 15 to 22 respectively. So this is free consent. The next topic is over. Next topic for discussion is 14. Competence of parties. Capacity of parties or competence of parties is the next point. Capacity of parties or competence of parties is the next party. When two parties want to enter into contract, the parties must be competent to enter into contract within the meaning of section 11 and 12 of the Indian Contract Act. One who wants to enter into contract must be a major. He must have completed the age of 18 years. If any guardian is appointed to look after his person or property, the minority extends to 21 years. So in such cases, he or she must have completed 21 years of age. For example, you may say that person or property, sometimes what happens is a minor boy is there. His father, he does not inherit any property from father, but from grandfather he inherits property. Then his father or mother may be natural guardian, or some other may be the natural. If the father or mother are insane or something, conversion or any renounced the word or something, some other person may be appointed by a court as guardian. That is his legal guardian. So if one who wants to enter into contract must be a major. That is according to section 11 of the Indian Contract Act. A major is one who has completed the age of 18 years. Who is a minor is one who has not completed the age of 18 years. And if according to Indian Majority Act 1875, then if a guardian is appointed to look after his person and property, the age of minority will be extended up to 21 years. So if guardian is not there, the minority, a person below 18 years is minor. If guardian is there, a person below 21 years is minor. So to enter into contract, the person must be a major. That means he must have completed 18 years or 21 years, as the case may be. That person alone can enter into contract. For example, a 5-year-old girl goes to jewelry shop with 1 lakh to purchase some chain. The jewelry shop man will not give. Simply he will ask, hello baby, who are you? Who is your father? Who is your dad? You brought this 1 lakh cash. He will naturally say. If he takes money and gives chain, if any police may come later and he will have to face the consequences. So to enter into contract, both the parties must be competent to contract within the meaning of section 11 and 12 of the Indian Contract Act. So according to section 11, the person to enter into contract must be a major. Otherwise, the contract is void. This was laid down in Mohri Bibi versus Dharmadas Ghosh. Mohri Bibi versus Dharmadas Ghosh, Privy Council, which was the court when prior to establishment of Supreme Court of England and prior to establishment of our Supreme Court in India, the Privy Council was functioning as the apex court. All these things I told in previously. So in here way, the Privy Council, which was the apex court, topmost court, supreme highest court in England, which heard appeals from India also, High Court of Calcutta, High Court of Bombay and High Court of Madras, and that court gave the judgment about in Mohri Bibi versus Dharmadas Ghosh. In that particular case, a minor mortgaged a property worth 20,000 to a money lender and received 8,000 rupees advance. Subsequently, he did not hand over the house and nor returned the money. The money lender asked, either you hand over the house or return the money. He did not do anything. Then the court said, when you want to enter into contract with minor, you must be very careful. The minor, if any benefit is there in the contract, minor will enjoy. If any loss or obligation is there, the minor is not responsible. Loss. So the case was dismissed. The claim of money lender was dismissed. So that is why a contract entered into with minor is void ab initio is the case. So further details I will take up in that next chapter. So minor. Second, section 12 tells that an insane person, a person who wants to enter into contract must be sound, must have sound mind, must be safe. Otherwise the contract is not valid. So here what happens is, suppose mental person, physically or mentally handicapped person, he doesn't know what is right and what is wrong. He is exempted from criminal liability also under section 84 of the Indian Penal Code. A person who got intoxicated by excessive consumption of alcoholic drink or consumption of food, drugs or something, his brain will be out of order. He won't be able to do what he is doing.
He is not in a position to distinguish between what is right and what is wrong. That is why an insane person, a person who is of unsound mind, is not qualified to enter into contract under Section 12 of the Indian Contract Act. To enter into contract under Section 11, the person must be a major. To enter into a contract under Section 12, both the parties must be majors. For 11, both the parties must be majors. For with reference to both the parties must be sound. So this is with reference to capacity of parties. Next one is lawful object or legality of object. Lawful object or legality of object. Section 23 coupled with Section 26 to 30 of the Indian Contract Act. When parties to the contract want to enter into a contract, an agreement, the agreement must be legally valid, legally allowed. It must not be prohibited by law. It must not be prohibited by law. An agreement entered into by two parties which is not declared void. So the agreement must, when they want to enter into contract, it must not be a void agreement. It must not be a void agreement or illegal agreement. The agreement must not be opposed to public policy. It must not be opposed to public policy. So gambling. Contracts for gambling, contracts for prostitution, contracts for maintaining bars where the consumption of alcoholic drinks is prohibited and like this. Whatever activity is prohibited by the government in the interest of public welfare, that the activity which causes damage to public welfare is taken up, that activity is opposed to public policy. Such type of contracts are studied under Section 26 to 30 of the Indian Contract Act. They are Section 26. An agreement in restraint of marriage is void. An agreement in restraint of marriage is void. For example, a rich man tells a poor woman, so I will marry you. You are very beautiful. I will marry you. In case after some time, if I leave you and leave you without providing any livelihood, you should not file a case. So this poor woman, she has no hope that somebody would marry him. At least this man is ready to marry. She agreed to marry. After some time of marriage, he left her, and then she filed a case. She can file a case against husband for restitution of conjugal rights, or if in the case of divorce, she can file a case for maintenance. So that man cannot say that on that condition only that you will not file a case. I married you, but now you are filing this. That man cannot say. So any agreement in restraint of marriage is void. Any agreement in restraint of marriage is void. It is one example under Section 26. 27. An agreement in restraint of trade is void, invalid. An agreement in restraint of trade is August 27 speaks about an agreement in restraint of trade is void. Any agreement against the conducting of any business for livelihood is void, because Article 19(1)(g) of Indian Constitution also guarantees freedom of trade and profession. The reason is, for example, A is doing business maintaining some provision shop for supermarket. Opposite to him, another started supermarket or any school like grammar school. Then A said B. So if in this small in this area, limited populated area, both shops are not necessary. You can stop shop and start it in some other place. For that I will give you some 5 lakhs. Okay, both is agreed for that. Then B closed the shop and shifted to another place. Then B filed but A did not give 5 lakhs. Then B filed a case against A. Then that is not void. That is not valid. Any agreement in restraint of trade is void. Any agreement in restraint of trade is void. This is some example. Now lawful. So 27. 28 means an agreement in restraint of legal proceedings is law is void. So law, any law the law, constitution is the supreme law of the land. Any central legislature, a law passed by parliament according to constitution. State laws must be according to central law and constitution. Local laws must be according to state law, central law and constitution. So any agreement made by parties, even for publications or the publication between author and publisher, an agreement between two tradesmen, an agreement between any two parties relating to property or anything, all agreements. Suppose there is a legal here, the other members of the property, I will give you, we will give you food, but after some time you should not inherit property. To that effect, an agreement is given. That is not. Suppose in a family, some members are there, one or two innocent members are there, but they are also entitled to get property. But the others, stronger members of the property, will demand a weaker member to enter into an agreement. So we will give you maintenance for a long time. We will not give any property. If you agree for this condition only, we will keep you at home. Otherwise, we will knock you out. That two innocent members of the family will continue and will give agreement that we only stay for food only. We will not make any demand for property. That agreement is written. Subsequently, these two innocent may file a case against. Why should we beg under them? Why should we live like beggars under them? Somebody suggested you ask your property and go out. Then at the instance of some friend or near or dear, they filed a case. Then these other elder persons should not say we allowed him to stay with us because he agreed not to claim any property. That is what they cannot say. Any agreement in restraint of law, opposed to law, whatever agreement is made by family members, whatever agreement is made by marriage parties to the marriage, whatever agreement is made by the trader, if it is against any agreement, must be according to the principles of law, provisions of law. Any agreement made against the principles of law is void, that is invalid. That is next 29. Next agreement is 29. 29. Uncertain conditions. The terms of contract must be clear. And they should not be ambiguous. They should not be confusing. Suppose A purchases oil from B. Sometimes coconut oil, sometimes ginger oil, sometimes sunflower oil. Then when A asked B to send some 10 tins of oil, you should specifically mention whether it is ginger oil or coconut oil or sunflower oil, he should maintain. Suppose send 20 liters of oil means it is not clear, the contract is not valid. Suppose A always purchases coconut oil only, send 10 tins, it is clear, the contract is valid. So the terms of contract must be this. So Harvey versus Fassi is a relevant case on this point. In this case, one party asked, I want to take your house for rent if the drawing rooms are fully decorated as per present style. What is the drawing rooms or how the drawing rooms are to be fully decorated according to present style? My house is heaven to me, your house is heaven to you. You may not like my house. You feel my house is very poor house, and some richer man may feel your house as a poor house. So what is the taste? What is the specification? What is the parameter for keeping the drawing room fairly decorated as per present style is an uncertain question. Such type of agreements are void. So this is another. Next one is possibility of performance. Possibility of performance is a terms of possibility of performance. What do you mean by the possibility of performance? A contract to be valid and enforceable, there must be possibility. It must be possibility of performance. Suppose a patient is about to die in a day or two. The doctor, he will ask the doctor, save me, I will give you all my property. But the doctor agrees, it is not valid. Suppose that one person, father tells my child, if you give life to my dead child, I will give you my 1 crore rupees. That agreements are impossible. Some impossibility known at certain time, impossibility is created subsequently. These aspects I will explain in a subsequent chapter in detail. When parties want to enter into a particular contract, there must be the party, it must be, there must be possibility of performance. If if you reach one place to another, walking if you walk 100 kilometers in 1 hour, I will give you 1 lakh. That is not valid. So possibility of performance must be there. When one party asks the other party to do a particular thing, it must be reasonable. According in the eyes of a reasonable and prudent man, it should be, there must be possibility of performance. There must be capability of performance. Otherwise, the contract is not valid. The impossibility, Section 56 of the Indian Contract Act enunciates that any contract, if any contract is contractual obligation cannot be performed due to impossibility, that contract is void. If impossibility is known at the beginning or subsequent impossibility, the contract is valid. Suppose the builder received money from so many customers for some 100 customers booked flat. He promised to give possession in 1.5 years. But due to corona pandemic, workers were not there. It is postponed for 3-4 years because of non-availability of laborers. Then the purchasers of flats cannot brings an action. Then the builder can establish that impossibility under Section 56 of the contract. Then the suits filed by the parties, flat holders, will be dismissed. So this is what is called possibility of performance. Finally, legal formalities. Legal formalities. When you want to enter into a contract, it must be registered date and duly attested. And the attested means witnesses should be there. Stamp duty must be there. That is there. Suppose one he wants to sell his movable property to be like 2-wheeler or 4-wheeler, the registration formalities must be completed. Next, with this, the ingredients or requisites or conditions of contract is over. Next, second part of the topic is kinds of contract. Kinds of contract, this is asked as short notes. First one is valid contract. Any contract agreement which is enforceable under Section 2H of Indian Contract Act is valid. And any agreement which fulfills the conditions under Section 10. Two competent parties freely consented to agreement, enter into agreement not declared void for lawful consideration, that is void. So why valid contract is that which is fully valid and is enforceable. Next, which agreement that fulfills these conditions will be valid contract. Void contract, Section 2J. Void contract means if any one of the condition is absent, that contract is void. Suppose Section 23 is there, it is void. Section 23, as per 23, a prohibited agreement is entered, it is void. If a lawful consideration is not there, it is void. The communication offer or abstraction is not valid, it is void. So lawful object is affected, it is void. These are the things. So voidable contract. Voidable contract means which is influenced by Section 15 to 20, 16 to 22, coercion, fraud, misrepresentation, mistake. If any contract agreement affected by coercion, if any contract is made by coercion under Section 15, undue influence under Section 16, misrepresentation, fraud under Section 17, misrepresentation under Section 18, a mistake under Section 22, such agreement is voidable. So please note that valid contract is 100% valid, void contract is 100% invalid, voidable contract is not 50% valid, 50% invalid. Either it will be valid or it will be invalid. If the agreed party questions or challenges, it is void. If agreed party does not question or challenge, it will be valid. If the agreed party keeps quiet, it will be valid. So next, A got married to B with a fear that B would commit suicide. Then I don't like to marry B, but she threatened me to commit suicide. I got her married. No, I don't want her further. He can repudiate the marriage. No, nothing there. Though I am not interested. She is a very good woman. She is giving good cooperation. she's doing very good. She's acting as very good housewife, and subsequently I like her very much. Here I want to continue. Then it is valid marriage like this. So unenforceable means those agreements which are not enforceable are not valid contracts. Unenforceable means an agreement cannot be agreement enforceable by law is contract. If agreement not enforceable by law is not a contract, it remains as an agreement. Suppose if you want to sell your two-wheeler, four-wheeler, mere possession is not sufficient. So you have to register it, the transfer must be done through registered instrument. Then only it is. If you simply take money, give your to scooter or car, that is not enforceable. In the event any accident takes place, if any problem takes place, so many problems will come. So that is why registration is a condition precedent for validity of that particular contract or transaction. Next one is time bound debt. If suppose a promissory note is 1 lakh is taken by executing promissory note, its validity is under section 3 of the Indian Limitation Act is 3 years. Suppose the debtor must repay the money to creditor within 3 years. If 3 years is elapsed, 3 years is completed, and debtor has no obligation to pay. But even though the debtor 3 years is over, out of morality, out of principles of morality, and the debtor may pay to this. So that is why time bound debt. So that is unenforceable contract. If the creditor files a case against debtor, if the promissory note is elapsed, is more than 3 year old, the suit will be dismissed. Creditor's claim against debtor will not be enforceable. That agreement is called unenforceable. Last one is illegal contract or illegal contract. Illegal contract is a contract entered into by two parties to commit an illegal act or legal act by illegal means. That is called illegal contract. It is called criminal conspiracy. It is an offence under section 120A of Indian contract, 1.120A of Indian Penal Code, and it is punishable under section 120B of Indian Penal Code. Illegal contract means A and B enter into agreement. A asked B to kill somebody to pay 10 lakhs. So that is illegal contract. A enters into contract with B to break the head of somebody. That is so. A enters into contract with B to burn the godown containing material. That is illegal contract. So so that is illegal activity. It is illegal by illegal. Sometimes legal activities are done by illegal means. Legal, suppose medical seat management quota is 1 crore, but the person who wants a medical seat may engage somebody. I will give you 25 lakhs. You manage the rank and see that my boy will get admission. That man will take 25 lakhs and through wrong route and changing the merit criteria in entrance examination by accepting 25 lakh. That is also illegal. If it is detected, if the fact is detected, the concerned parties will be arrested. So these are the various issues relating to contract, meaning, definition, elements and kinds of contract. Thank you very much, dear friends, for your patient hearing.